We've got a couple of good mornings on our YouTube chat, and I just now realized that we hadn't gone live. This is our first show. We're going to be working out a couple of the kinks this morning, and I appreciate all of your patience with me as we work through some of these issues. So, as I said just a moment ago, we're live both on YouTube as well as on KRFE, the home of Buddy Holly. And so we're going to be discussing this morning some of the laws that dictate what controls our daily lives. What I want to discuss this morning is a topic that's a little bit close to home to me, probably close to home to a lot of you. We're going to be discussing wills. I know that's the most exciting topic that you all want to discuss this Friday morning, but it's something that is going to affect all of our lives. At some point, you and your family are going to need wills. That is, unless, let me take that back for just one moment. There's one class of people who does not need a will. If you trust the government to take care of you and your family, you don't need a will. Because if you don't have a will, the government, the laws have already dictated exactly what's going to happen with all of your property after you pass away. They already dictated which of the people in your life are your heirs. They have already dictated which of the people in your family will get property, and they've already dictated which of the people in your family won't get any of your property. And so if you trust the government, you don't need a will. For the rest of us that don't trust the government to take care of our families after we're gone, we need a will. And so what does that look like? Let me take just a moment and discuss some of the people who, or some of the myths surrounding wills, because there are a lot of people who just simply don't get wills out there. There are some people who are superstitious about getting wills because they think that if they get a will, all of a sudden now something bad is going to happen to them. Let me tell you a story. I had someone who was even on my staff in my law firm here in Lubbock a while back because we offer free wills to all of our staff. Free of charge. I mean, it's the least that we can do for people who are working for me. And we had someone who was on staff who said, no, I don't want a will. I don't need a will. If I get a will, then all of a sudden something bad is going to happen to me. I'm basically signing my death warrant if I sign a will. And so they said no and refused, never got a will. And what I have learned is that that's not unique to people who work in the legal industry. I've met clients because I do primarily family law. I do a lot of divorces. I do a lot of custody. We also do wills. We do probate and guardianship, estate planning and business. And people across the spectrum, unfortunately, have some of the same superstitions. And what you need to realize is that signing a will does not sign your death warrant. Signing a will is a responsible adult thing to do. And without a will, what you're going to do is you're going to cost your family a lot of extra money. So superstition is fine. You can have superstition so long as you're willing to pay for it. So if you know that you're superstitious about getting a will, which cost about $300 anyway, if you're superstitious about getting a will, then just first go ahead and set aside about $10,000 for your loved ones to take care of your estate after you're gone, and just let them know that, listen, I set this money aside so that way you can pay to take care of my estate because I was superstitious. You might not be superstitious, but you might just be a little bit stitious. So if you have a, let me go back. There's some people who are afraid of getting wills. Oh, hang on, let me look to some of the people in our YouTube chat. We've got some good mornings from Miss Samantha Terry. Good morning, Samantha. It's good to see you in here. Ashley, good to see you this morning. Denise, good to see you. And Eddie, good to see you as well. Thomas, Weather Watch, it's great to see you here in chat too. So one of the difficulties for people in getting wills, one of the reasons that holds them back is the confusion. It's a legal process, and a lot of people just don't really know where to start. The downside is that whenever people don't know where to start, is they just don't do anything. They don't know someone that handles wills, or they don't know what goes into the process. They're afraid of how public this is going to be. And so what I'm going to do is explain how easy it is to have a will, so that way you have no excuse to not have one after today. So in Texas, and even though we're discussing Texas law here, I know that some of our radio listeners are might be over in New Mexico. Some of you listening online can be around the world. But a lot of the laws that we're going to discuss today, the same principles apply in most states and even in other countries. So whenever you write a will, in Texas, we have two different types of wills. We have what's called a holographic will, which just means that it is completely in your own handwriting, meaning you have to literally handwrite every single word, sentence, paragraph for your will to be valid. Then we have typewritten wills, which is 99% of wills out there. That's what is typed out, explains all of your goals and wishes for your property, appoints executors, and that sort of thing. So this typewritten will is simple. Really, whenever you do either a typewritten or holographic will, the same principles apply to both, but just remember, one has to be completely handwritten and the other is typewritten. And the typewritten wills are going to have witnesses, disinterested witnesses that are at least 14 years of age. This is a lot easier than most of you would realize. Weatherwatch, I see you in chat here on the YouTube channel. And I'll read these for those of you listening on the radio. Weatherwatch says, I'll get a will, but the second I get life insurance, you know what happens next. You know, there are ways that, and something that you might not realize, Weatherwatch, is that whenever you have a life insurance policy, that passes outside of your will. Now, you can set up your life insurance to pay to your estate if you want, but your life insurance policy, you normally pick one person or a group of people who are going to get that life insurance policy, and that never actually touches your will. So you're safe if you get a life insurance policy, whether or not you have a will. But the will is going to cover, because your life insurance policy doesn't pay out until after you have already passed. Your will covers all of the property that you have or that you would have upon your passing. Something to consider on that note is that you don't write a will based on the property that you currently own, but all the property that you could have. So this is the example that I like to give everyone. I'm going to pick on the people at City Bus. So if you were to step off the curb tomorrow and you got taken out by a city bus, now your estate could be entitled to some sort of payout. Well, even if you didn't have a dime to your name as you sit here today, or as you write your will, that policy, or not policy, that payout, that settlement, that recovery that you get for that cause of action, if let's presume City Bus was negligent here, that payout would then be paid into your estate. Now that property has to be divided. That doesn't pass outside the will like a life insurance policy would. So that's the simple explanation of what goes into a will. It is a will is as simple as explaining, here's who gets my property. That's it. If you sat down today and hand wrote a will, make sure you date it. My name is so-and-so, all in your own handwriting. My name is so-and-so, and I desire all of my property to go to so-and-so upon my passing. Make sure you sign it. That has just now created a holographic will. If you want to do a little more than that, like designate an executor. Executor is the person who is going to handle your estate. They're appointed by the court as the executor, and they're the ones who can sign off on things to handle your estate even after you're gone. But if you have not designated an executor, unfortunately, there's going to be a little bit more work in the court process. And that's the reason that we're going to focus our time today on discussing the typewritten will, because a typewritten will is going to set out who your executor is. Who is it that you trust most to take care of your affairs after you've passed away? Let's go back to the chat for just one moment. We see a question, or I'm sorry, a comment here. Eddie says, the day we wrote our will, my mom died. I'm not superstitious. Life happens until it doesn't. Eddie, I'm terribly sorry to hear that. But on the bright side of that, if there has to be a silver lining to a terrible situation, is that as soon as you, and I'm presuming that what you mean by that is that your mother got her will done that day, as soon as she got that done, she had handled her affairs. She felt confident knowing that her family was going to be taken care of, knowing that her affairs were in order. It's one of those things that unfortunately we have to handle, that most people end up handling very late in life. For a large majority of us, a large portion of us, unfortunately, we don't get that option to make a will very late in life. Accidents happen on a daily basis. The newspaper is full of people who met their demise way too early. And so they didn't get that ability to get their affairs in order late in life. And also something else to consider as we watch the news in today's day and age is that unfortunately, a lot of us are going to survive past a point where we have the mental ability to make a will, because you have to be competent in order to write your will. And so if you have lost your ability to be competent to decide where your property is going to go, you lose that ability. That will goes away. It's treated as though it did not exist. And your family then is kind of at the mercy of the government on how that property is going to be divided. Let's talk about some of the costs that are associated in getting a will. So the costs associated with getting a will are minimal. I say minimal. I said $300. That's just what we charge to do a very simple will. A very simple will just says that I want my property to go to one or two people, or I don't want any of my property to go to so-and-so, which we call you're just writing someone out of the will. And so if you're just doing a simple will, it's about $300. I know a lot of attorneys are going to charge different prices, but that's just what we charge. Speaking of wills, Weather Watch on our YouTube chat asks, does getting your typewritten will notarized help? Yes. So whenever you do a typewritten will, one of the things that you would want to do is it's called a self-proving affidavit. So whenever you have passed, or let me change for a moment. I'm going to stop killing all of you off for a minute. So whenever a loved one of yours has passed, then you need to probate that will. That just means to file it in court, to get it approved for one of you to act as the executor and to be able to take all the actions necessary. Well, whenever you probate that will, if it has been witnessed by two people, those two people will still need to come to court to testify to say, yes, I witnessed the will and they were competent and they knew what they were doing and they knew that their estate, and they knew that they were signing a will, they knew that they were giving away that they were designating who would get their property upon their passing. But with this, what we call a self-proving affidavit, we handle all of that at the will execution ceremony. We have an affidavit that's allowed under, at least under Texas law, that allows those two witnesses to sign this affidavit saying, this is this person was competent. I did witness it. I am a disinterested party. I'm not getting part of the will. And that affidavit means that we don't have to go and find those witnesses anymore and drag them to court to come and testify that you knew what you were doing. So, Thomas, yes, to answer your question, getting it notarized absolutely helps for that self-proving affidavit. As to the will itself, not so necessary for the will to be notarized because you're not swearing under oath. It does help. Well, because in Texas, you need to have those witnesses to be able to testify that we saw him or her sign this will, and that's sufficient. Got another question here from Recovery Addict. And for those of you that don't know, Scott and Thomas Weatherwatch that I've just now referenced here, great friends of the channel. I've known them for quite some time from Scott's channel on the Recovery Addict YouTube channel. And so what he does is he covers live court proceedings. And so if you're a big fan of true crime, check out Recovery Addict on YouTube. We're going to see if some of these commands in chat will show up on YouTube. Hey, look at that. We're getting some work. All right, so for Scott's question, do I need to have a will in a safe deposit box, or can I just scatter copies around my house and hope they get found after I pass? Well, maybe a little bit of both. So you could, what I always recommend is to, number one, your will, you want to have your original. You want to have it somewhere safe, like a safe deposit box, in a safe at the house. Some attorneys will even hold on to a copy of it for you, for infinity. And some of them do that for a small fee. I mean, what attorney's not going to charge some small fee for any small act? So that original will is very important whenever it comes time to go and probate it. However, it's not a bad idea to have copies. And so if you know who your executor is going to be, it's not a bad idea to give them a copy of that will, show them the original, show them the copy, so that way they can show up later on, because that's one of the rules of evidence, is allows you to submit a copy in place of the original if you have someone that can say that I have viewed the original and I have viewed the copy, and the copy is a true and accurate copy of the original. That seems really convoluted, but that's how the law is. So with the copies, you can, it's not just so much about having this paper copy scattered around the house. You can also have a scanned copy, because remember, if you're just printing it off just as well as you're hitting copy on a copy machine, that's going to be just as sufficient. However, the important thing is to make sure that whoever is going to have these copies, that they have viewed the original, if that's what's going to be used, or if there's a possibility that the original could be lost. And that's going to bring me to one of my next topics. So, give me just one moment. So, one of the other reasons that people don't get wills is because they are afraid of what sort of strife, what sort of conflict that this is going to create within the family whenever they say, I want this child that I believe to be responsible and they can take care of this property. I want this child to get my house, and I want this child who has a severe drug problem to get nothing. They trust one child to take care of the other child and if necessary, or they just know that if they give that problem child any property, that it's literally going to go up in smoke. And so if those children see that will, obviously that might create a little bit of conflict within the family. So that might be one reason, Scott, that you might not want to have multiple copies of wills scattered around the house. However, having a best friend that really knows that they don't want to create any drama, that's a great starting point for who should have copies of those wills. Something that you might not know is that you don't have to tell any of your heirs who or what they are going to get upon your passing. And in fact, that's pretty rare to tell them in advance that, hey, here's a copy of my will. And so now you know how much that you're getting. Otherwise, you can see some of the problems that might create if all of a sudden your problem child realizes that, oh, hey, I'm getting an equal share of everything. You know what? I could just bump mom or dad off and let's just speed up the process a little bit. And so, and I use that as a joke here because obviously you wouldn't be able to recover under a will if you were to cause the death of the person that you were trying to recover from under the will. But the necessity of telling them in advance, there is no necessity to tell anyone in advance. It's very uncommon to give them copies of those wills. One of the things that having wills does in reducing family conflict, though, let me tell you, I'm going to tell you a couple of war stories. So I had one of these cases that happened many years back, and I thought that it was unique. I thought it was movie worthy until I saw it happen more than once. So on more than one occasion, I have seen cases where a secret second family shows up to the funeral home upon someone's passing. And so obviously you can see what sort of conflict that could create legally, never mind how much conflict that created during the funeral itself. But if you don't have a will, I mean, I'm speaking to all of you out there that have secret families that your real family don't know anything about. Because I know that there are some of you out there listening because this keeps happening even here in Lubbock. So for those of you that have secret families, please, for the love of God, get a will, because otherwise, here's what's happened in these cases. Both of these, or all of these people that I've known that have, or had to represent the estate of after they have passed, didn't have wills. And so both families showed up to, I think one of them was the hospital and one was the funeral home. And so with no paperwork, both wives showed up and said, here's my marriage certificate. I'm married to so-and-so, so I want him sent over to this funeral home. And the hospital said, whoa, normally it would go to the wife. Normally the wife is the one, or the spouse for whoever, would be the one who would handle this. But since it's not very clear right now on which one of you is actually the spouse, we're not going to do anything. The hospital just stood by and said, y'all need to go and get a court order. Now, even though we're talking about wills here, some of the other ancillary documents that we normally do with drafting wills as part of what we would call an estate plan is a designation of agent to control disposition of remains. That's a mouthful, but essentially that's the person who gets to direct whether or not you get cremated, buried, where you get buried, how you get cremated, where you get scattered. They get to decide all of those things. You trust them. You can give them some guidance, but they are the ones who obviously make that final decision. In all of these cases where the person who passed away did not have this estate plan, or they didn't have this designation for remains, and they didn't have a will, for all of these, we had to go to court and we had to fight. Both spouses got attorneys, and we litigated so long, and the decedent sat in the morgue for so long that they were no longer able to have open casket funerals. And so if you want to talk about the heartache that not having a will causes, that's one of them. That's some family conflict that's going to last for generations. That ruined a lot of people's opportunities to say those final goodbyes at the funeral. And neither of these were expected passings. These were not, lived well into old age. And sometimes it's not necessarily that someone had that secret family. It's that someone thought that they were secret family. They thought that they were married. because Texas is a common law marriage state. So you can get married by common law in Texas. So if someone thinks that that they're married and they show up and they create that sort of problem, the hospital is going to protect its own interest, and the funeral home will protect its own interests, and just ultimately not take any action at all. Let's talk about some of the costs. Actually, here, while I'm covering some of these costs in just a moment, I'm going to ask the chat here on the YouTube channel. I'm going to ask the chat if y'all have any questions that I can answer here live on air. And by the way, we're going to go for about another 15 minutes here of explaining. And so I promise I'm not going to take the entire morning of explaining wills and us talking about your untimely demises. But I want to make sure I answer as many questions as I can. The costs of not having a will, I've already kind of explained, is that it can be astronomical because attorney's fees are expensive. It's obviously going to depend on where you live. If you live in a medium-sized city like we're here in Lubbock, Texas, the attorney's fees are going to run you about $250 to $300 per hour. It could be far more than that. There are some attorneys here that charge $400, $500 an hour. In big cities like Dallas, New York, Los Angeles, their fees are insane. They might start at around $500 to $600 per hour. They're going to require from your family who's just now mourned your passing, they're going to require a $3,000 to $5,000 deposit just to get started on administering your estate because you don't have a will. We have to track down all of your heirs. If you don't have a will, then we have to find out everyone that you've ever been married to, everyone that is a child of yours. If you have a child that's passed away, then all of their children are now your heirs that have to be taken care of. They have to be accounted for. And that's something else that we've seen, unfortunately, is that some people will ignore the problem. And as we all know, if you ignore a problem, it's definitely going to go away and it's all going to work itself out, right? Unfortunately, that's not how it works when it comes to real property. So if you've got land, because out here in West Texas, we've got large, open, sprawling farms, farm-wide. And what we have seen is that if someone passes away without a will, the family just keeps taking care of the farm and keeps taking care of the land. Sometimes family members will show up and they'll take care of it for a little bit and then they'll move on and another family member will take care of it. Well, years and years pass and those family members pass away. And now we have a farm or any plot of land. It could be a city plot just as well. Any piece of property out there is still going to have that original person's name on it. And so we still have to go back and administer that person's estate and then that person's heirs' estates until we have taken care of all of your different levels of generations to make sure that the property goes where it's supposed to go. Now, imagine for a minute how much money that costs for you to pay attorneys to have to handle all of that. And on top of that, whenever you go to administer that estate for all of these unknown heirs that are out there, unfortunately, you're going to have to pay for an attorney for all of these unknown heirs. We call that an attorney ad litem. And so, as you can see, the cost, they get to be astronomical. Go into the chat here for a moment. Cyber Rider asks, what if I'm left something in a will and do not want it? Great question. So if you are deeded something, or I'm sorry, if you are willed something that you do not want, then you don't have to do anything. You can, you literally do nothing. Ignore it. You don't have to probate the will. You don't have to file anything in court. You can just ignore that because you don't care what happens to it. If the will has been probated, And so let's say that, your family member just did not like you. Whatever you did to upset them, they were unhappy with you. And they said, okay, this swampy, nuclear dumping waste site, I'm going to deed that to Cyberwriter here, and let them take care of it. You can just simply file a disclaimer that just says, I know that I'm willed this property, I don't want it. And then it passes as though you were no longer alive. And so whoever else was in the deed, or I'm sorry, whoever else was in the will to get property, it's gonna default to whoever was second in line for it. The one more question in chat. Amber Saker asks, if I have a holographic will and I own property in 2 different states, how is that handled? That's a great question. A lot of that's going to depend on what different states that property is located in. This is a great question for you to ask with a local attorney. Find someone local that you trust. Most attorneys will do just a simple 1-hour consultation just to answer some of these questions. They can look at how this property is going to be handled, and it's going to also depend on your marital status. And so let's say that you're married and you own, your perfect house with your white picket fence, and you sign a holographic will that says, I want this property to go to my child. Well, you can never give away more than what you have. So you can't give away your spouse's share of that community property. You can't give away your spouse's half of that house. You can only give away what is yours. Jen Joe asks, I set up a transfer on death deed for the property. My understanding is that means the property doesn't have to go through probate. Is that correct? Depending on your state, yes. Texas does have something called a transfer on death deed that allows you to transfer this property. That helps to avoid probate, but that doesn't necessarily mean that you don't need to have a will, though. That will is going to cover everything that is yours or that you are entitled to now or in the future. So let me clear up one common misconception for a moment. A lot of people think that, well, I'm married, I don't need to have a will, because as soon as I pass away, everything's going to go to my spouse. That seems right. I mean, that sounds logical, right? Not quite. So in today's day and age, and not just today's day and age, in future years, because hopefully if you sign a will today, we're all praying that you're not going to need that for many, many years to come. But in today's day and age, we know that we have a lot of blended families. We have a lot of families that have stepchildren. We have remarriages. We have second and third marriages. And so let's just presume for a moment that you're on your second marriage, and you and your new spouse, and let's say there's not even a divorce the first time. Let's say your first spouse had passed away, and you're now on your second marriage. So if you and your new spouse, y'all have some property together, and you pass away, you don't have a will. If all of your children, and your children are not your new spouses, or let's say that you do have some children with the new spouse, if 100% of your children are not the children of your current spouse, then your spouse does not get all of your property. I'm sad. It's sad to say that. And unfortunately, I've had to break this bad news to people from time to time. If there are children that are not of your surviving spouse here, then only half of your community property goes to that surviving spouse. And so remember, that's the community property share. And so you can't give away more than what you have. So your current spouse gets their half of that community property. And again, I'm talking about Texas law here. The other half of it then gets divided to all of your descendants. And so and we're talking about your half of the community property. So you might have adult children from your first marriage that, they haven't been around for a while. You might have a lot more property that you and your new spouse had acquired together. Well, those children without a will are going to get half of all of that property that you and your new spouse have accumulated together. Let's also talk about, what about that separate property? So let's say that you owned a really large farm prior to getting married. And so to this new spouse, you and your new spouse have this property, one property together, but you own a farm prior to the marriage. We're going to call that separate property, because the same applies to any of your separate real property out there. Your spouse gets a 1/3 life estate. That just means that this separate property that your current spouse didn't have any participation in acquiring. It was a farm that was passed down through generations. They get a 1/3 life estate in that property. And then the remainder of that is going to be the remainder interest in that 1/3, and the outright interest in the remaining 2/3 goes to the descendants. I know that's really complicated to explain here, and we're running short on time, but suffice it to say that if you are on a second marriage and you have children that are not of your current spouse, you absolutely need to have a will to make sure that your current spouse is taken care of. As we work through some of these last questions that we have, Jinjo, I see here you commented that this is exactly what happened to you. That's unfortunate. I am terribly sorry to hear that you had to go through some of this that we're talking about here, some of these horror stories, that you were told that you would get half of your home and property and the kids would get the other half. Oh, that's heartbreaking. And it's heartbreaking that you have to learn this from a stranger, from an attorney that you're paying by the hour to explain this to you. And most of them, like I said, most attorneys are charging $250 to $300 an hour in most cities. And this could have all been fixed with a simple $300 will. Instead, and Jinjo, correct me if I'm wrong on this, but I bet that you had to pay some pretty good money to learn that to an attorney after your husband had passed away. So we're going to conclude right there for today. Let me first end by number one, thanking you all. Oh, Jinjo, $20,000 in legal fees for the probate, and nobody was fighting. That is heartbreaking. And that $20,000 in legal fees would have been saved with a $300 will. That's probably even more heartbreaking to learn that if you didn't already know it. So we're going to conclude our discussion on wills today. It's my goal to educate the public, because as I said in the beginning, an educated society is a free society. If you haven't found the Matthew Harris Law YouTube channel, go check us out. Every single day, every weekday, we publish a legal pop quiz where we explain to the public, or I'm sorry, where we teach something new every single day. Every week we might have a different topic that we're going to quiz on, but it's multiple choice. And by the way, if you get the answer wrong, you can correct the answer, so that way you feel better about it. But find us on YouTube, participate in some of these quizzes, because it's going to help to educate you on some of our laws. Also, we publish YouTube videos every Thursday by noon. Check out some of the videos, make sure that you're staying informed. I'd ask you to consider subscribing. We're going to be back here on KRFE radio. For all of you radio listeners out there, we will be back on the radio in 2 weeks. So I'll be back here same time, 8 a.m. on Friday, July 26th. And then we'll discuss the schedule as it goes after that. We're going to go offline on radio. And for those of you who are watching on YouTube, I'm going to portal you over to Scott at the Recovery Addict channel. If you'll give me just one moment to set that up while we go offline with radio. And if you have questions, don't be afraid to ask those in the comments on the YouTube channel. I do my best to answer as many questions as I can. Obviously, I'm still a practicing attorney. I still have an active caseload. But as you go about your daily life, make sure that you are educated. The government is not going to look out for your best interest. You have to protect yourself. You need to know your rights. And to do that, you need to know our laws. So with that, I thank you very much. Good. Good. Okay, for those of you on YouTube, give me one moment. We're going to get you portaled over to Scott, if we can get that figured out. Okay, unfortunately, I'm not able to find, I'm gonna have to work on that on a future stream. So unfortunately, I can't find a way to portal you all over. Let's see if we can put a link in chat. Because that's where we're gonna conclude. We're gonna go offline now. Thank you all so much. I appreciate you being here.